Family disputes can make us feel isolated and vulnerable. Maybe you're going through a divorce or a legal dispute about your kids. Perhaps you've spent hours on Google or have even posted anonymously on Facebook to see what others have to say. But are you getting the actual information and support that you're looking for? Our podcast, Legal Lounge, aims to dispel misinformation and downright bad legal information to empower anyone with questions about their family, their children, their finances, their marriage, and the law. As a team focused exclusively on family law matters, we aim to help listeners not only with the information they need, but also with the hope that their situation has a solution. Short disclaimer, please note this podcast is for educational purposes only, and the information should not be relied upon as legal advice or for legal purposes.
Hello and welcome back to the Legal Lounge podcast. You might be thinking, that's not Theresa. Well, my name is Kristen Stegall. I'm the producer of the podcast, and I am here with Theresa Viera, the host of the Legal Lounge podcast. But today we have a very exciting hot seat Q&A episode about a not so fun topic, which is custody arrangements. But specifically, we're going to talk a little bit about some pop culture custody arrangements and what we can learn from those. Theresa, welcome to your podcast.
Thank you. It's so nice to be here in the hot seat. Short notice to the listener. I do not know what she's about to ask, so I hope I don't stumble too much, but I'm excited for this episode. It's going to be an exciting one.
Yes, I'm excited too. So the first question that I want to ask you is about one of the most popular reality shows of the year, which is The Secret Lives of Mormon Wives Season 2. Popular enough that Indian Land, South Carolina got a swig, which is really popular on the show. If you know, you know. And it has a line that backs up to the highway since the day that they opened in June.
What's a swig?
Swig is a soda shop where you can get like different flavored sodas and like add all these different mix-ins to it. Because in Mormonism, you can't have hot caffeine. You can't have coffee or tea, but there's kind of a loophole where you could drink soda. So for every Starbucks in Utah, there's a swig.
Interesting. I just learned something new. Soda pop. Sounds good.
Yes. So in season 2, there is a couple that shares custody of a baby. They were not married, so there was no divorce or separation, to my understanding, or I don't know if there's a formal separation process if you have a child. That's maybe part one of the question. This is all in the state of Utah, but they share joint custody of their child that they have together. But she also has 2 children from a previous marriage that she has joint custody of. So my question to you is, how does it work when you have multiple custody arrangements with different partners? Does one custody arrangement get taken into consideration for the next custody arrangement, or how does that work?
Sure. So I will say there's obviously no formal separation process, but logically when parents decide not to be in a relationship together, or maybe they were living together, now they're living apart, there's definitely a need for some type of parenting arrangement, both in terms of parenting time as well as decision-making authority and who's making decisions about the welfare decisions for the children. But we run into that issue a lot because we have clients, not on reality TV, but for the most part, we have clients that will have children of a previous relationship, and then they have children with another relationship. And although it's not required, yes, we do try to take into consideration how the custody arrangements work for both sets of kids or children. And I say that because, if we do have these, half siblings or step sibling situations, 9 times out of 10, all adults involved want some type of relationship to develop between the children. I would argue that's a healthy way to acclimate to a larger family situation. And so it doesn't really make sense to have, 1 or 2 kids on one weekend, every other weekend, and then have the other kid every other weekend, and they only see each other maybe on holidays and in the summer. And so courts will consider that and will consider maybe overlapping the custody arrangement so that all the children can spend time with each other. Now, of course, we've also had that very fun, not so fun situation where maybe we don't want a certain child interacting with another child, maybe because one of the children is 17 doing drugs and kind of not doing the best in school, and they're being exposed to the 5-year-old who's actually doing pretty well and is about to start school, and we want to set a good example. So all of that really depends on the specific circumstance of the children in that family. But yes, I'm sure that mother's hands are full with multiple custody arrangements.
Yes. And if you're watching the show, you know that that is definitely true. And it does look really stressful to have that arrangement. And, the other question I have is, does custody arrangements, or do they differ for a couple that is married and they're getting a divorce from a couple who has a child but they're not legally married?
At least in North Carolina, not so much.
Okay.
I mean, a child being born is the utmost priority, period, their welfare. So, there's something to be said where, yes, arguably individuals in a married relationship may be viewed by a court or in a negotiation session as a more stable relationship. However, people divorce. So that's not necessarily that different from a boyfriend-girlfriend having a baby, or even, say, a same-sex couple adopting a child, regardless of marital status. Because at the end of the day, what really matters is what's going on with this child. How can we best serve the needs of this child?
Got it. I'm also curious about, are there any parental rights that a step parent might have if they grow, attached to the children that their spouse had from a previous relationship, and then they get divorced? Do they have any parental rights to those stepchildren?
Speaking of interesting shows, I can't remember the name of the documentary right now, but there's a documentary on Netflix about a similar situation.
Okay.
A bit sadder of a situation. But short answer, no. They don't have much rights. Not to say that they are completely barred from asserting any type of rights, but simply put, the biological and or adoptive parents will always have a constitutional right to parent the children as they see fit, and that includes having right to access and decision-making authority over the children. And the documentary I'm thinking of is about a situation where a husband and wife have 2 kids. Wife passes away, unfortunately, due to an asthma attack or something specific to her. He hires an au pair, and mind you, they're in, I believe, Ireland, and the au pair happens to be from the United States. So this chick, is what I'll say, moves over there, is an au pair, and does, in a way, assume the responsibility of a mother, of a parental figure. They happen to fall in love to the extent that they get married. The father and the 2 kids move to the United States, closer to where the au pair, now wife, is from. Even kind of crazier story, wife, and more specifically her father, end up killing dad.
Oh my gosh.
Which was crazy. And so these 2 kids are kind of left in limbo because neither of their biological parents are living anymore. And specifically in that case, when she tried to assert the fact that she was their mother, aside from the whole murder situation, the courts were like, well, no, ma'am, you never adopted them, and they're not your biological children either. And so the children actually ended up going back to the home country. And I found that very interesting because my poor husband, as he was working on computer stuff upstairs, I was like, they're not your children. And I was just thinking of the legal situation surrounding it, where it's like, yeah, there's something to be said that at the end of the day, yes, I admire all the step parents that do step up for children because they're the children of their new spouse, or they go through the process of actually, treating the children as their own.
Yeah.
But to all the step parents out there, if you actually want legally protected rights to that child, you have to go through the adoption process. Now, I'm not saying that that's necessarily an option for everyone, because that does require possibly a termination of parental rights or consent of giving up parental rights by one of the biological parents. But that is definitely something to entertain if you, in fact, do want those parental rights protected.
That's really good to know and very fascinating information, because I do think that there are situations, and I'm about to ask about a dating scenario in particular, where maybe you start dating somebody new post-divorce, and then that person gets attached to the child, but then how do you navigate that relationship? So there's a YouTuber that had a very public divorce over the last couple of years, a very not amicable divorce, especially when it came to like ownership of her YouTube channel and her spouse trying to come after the revenue from the YouTube channel, claiming that he had part ownership of it, all that stuff. That's all like very fascinating. We need to have you and Gabriella have a conversation about that.
Juicy equitable distribution, property matters.
Yes.
Love that argument too.
And how does that work? But so they were separated. And this is in the state of California. They got separated, and then just a couple months after their separation, her ex-husband introduced their children to a woman that he was dating. And she said that they had agreed to not introduce any new partners to their children after a certain period of time, but I don't know if it was in writing or not. And so my question is, can you actually dictate at what point your children that you have with your ex-spouse are introduced to any new partners that come into the picture?
Oh man, this episode could be hours long just on that question. Building relationships is a natural part of life. But how does the law affect those relationships? Do you want to marry your significant other, but have cold feet from the many divorce horror stories out there? Are you preparing for a custody battle against your ex? That is where Modern Legal comes in. We offer education and knowledge about the law when it affects the relationships near and dear to your heart. To learn more about how family law affects your family, book a consultation with an attorney of our Modern Legal team by visiting our website, emailing us, or calling us at 704-286-6302. Check out the information about Modern Legal services at modernlegalnc.com. So we run into that question a lot, especially if one of the spouse's parents cheated during the marital relationship.
Okay.
Because as you can imagine, once the parties separate, that cheating spouse will probably continue the romantic relationship with that paramour, and they may want the children to meet them sooner rather than later. So we do have, I'll say, legal language here in North Carolina specifically that on occasion judges have included, but it's definitely falling out of favor nowadays. But it's the romantic partners provision that basically states that neither parent will introduce a romantic partner to the children unless they get married prior to a certain period of time. And I get it, especially here in North Carolina. We do have the year of separation, so it takes a year and a day before either party can actually file for an absolute divorce. And so it's not necessarily unreasonable, at least from my personal opinion, to request that, hey, let's wait until the divorce is done before you introduce another romantic partner. However, different circumstances apply to different families. Who knows? Maybe the parties were actually sleeping in separate bedrooms and were having an open relationship years before they actually separated and pursued divorce. But we try to negotiate that provision just because essentially both parents have equal rights to the children unless there is a parenting arrangement or agreement or court order stating otherwise. So if one parent doesn't like the other parent introducing the new girlfriend or boyfriend, theoretically that parent, the one who doesn't, like the new person, can keep the kids, and there's no requirement that they turn over the kids to the other parent.
Wow.
Same vice versa, though, right? Because the other parent who had the affair could keep the kids as well. And that's where we get this struggle and this pushing and pulling and snatching situations that we as a judicial system and a family court system are trying to avoid as much as possible. Because at the end of the day, trust me, the kids probably don't care about the cheating situation, about the marital relationship. They just want to know that they're going to be in school on time, get to hang out with their friends, and be at soccer practice on time with their gear, right? So we do negotiate those provisions, but they're definitely not a standard provision you see in custody orders today.
And so the penalty could ultimately be that one parent loses custody over their children?
Not necessarily loses custody, but a court could take that into consideration that they're violating an agreement about that. And I say could because, I mean, judges are going to say, hey, at the end of the day, parents can parent as they see fit during their parenting time. And simply exposing a child to another adult that will likely be pretty involved in their lives does not necessarily equate to child abuse. Now, I have had the case where the third party individual, the paramour, or whatever you want to call them, did have some concerning behaviors, such as a number of criminal convictions or gang-related activity and drug trafficking. So I will say that, like, there have been those situations, but fortunately, those are rare and few and far in between. So, so yes, but no, but yes.
Okay. Got it. So they can, so you could technically have a romantic provision.
Yeah.
And I'm sure it all comes down to your point, how contentious was the divorce? Is it just a matter of one partner trying to still control the other partner? Or is it genuinely, you know, I don't want our children to get attached to a new person that might not be in their lives forever? And being able to have that conversation with your ex-spouse, which could get tricky.
Could get tricky. Let me add a caveat here. Look, courts and the law can only do so much, right? And the goal, hopefully for both parents, is to do what's best for the children. So if we do have a parent that has a new boyfriend or girlfriend every other week, come on now. We don't want the children to be like, oh, I like this new person. Oh, they're gone. And there's another new person. Oh, they're gone, right? And that's more so because you're creating a tumultuous environment for the child. Forget the other parent for a second.
Yeah.
Like when I talk to my clients, I'm like, okay, there's the law and then there's reality. So let's think through actually what is best for the children.
Yeah, absolutely. So one thing that my husband and I joke about is that if we ever got divorced, we would buy like a duplex and split the house. Like one of us would take the upper floor, other would take the bottom floor. And that way we could see our son whenever we wanted to, or like just have close connection to our child and not have to worry about driving across the city to, you know, split custody or things like that. Have you seen anything like that?
Yes.
In your experience, and how does that play out?
Love that. But 99% of human beings are not mature enough for that type of arrangement. And I mean that with a full heart.
Yeah.
I mean, I have heard stories where, you know, duplex, it'll be like a townhouse situation side by side, or maybe even like one person has a house and then, you know, 2 doors down across the street is the other parent's house. And I love that because then they can, you know, both look outside their, I don't know, kitchen window above the sink and see little Johnny running between the houses.
Yeah.
And just be free to hang out at whichever house that the child wants to visit at that point. Now, I do believe that can work. I believe there are similar arrangements that have worked as well, maybe not necessarily having a house on top of each other or right next to each other. And that could include, for example, having joint birthday parties or having, I know a story of one divorced couple where every year they would take family photos for the child. They did not like each other, but they sure did smile in that family photo every year because they reminded themselves it's not about them.
Yeah.
It's about the child they share. And thankfully, that child from birth through graduation of high school now has a family photo with both of that child's biological parents.
Yeah.
Which is fantastic because that shows that the parents are mature enough and willing to put the child's needs first enough to come together on certain circumstances. Now, on the flip side, let me please note to all the parents who are like, okay, well, that's a fantastic idea. I'll broach it with my ex or other parent. It's not necessarily good to try to force it because we also don't want to turn a fun birthday party into World War III, where we have, the glares across the room from one side to the other. And then one parent is like, well, I'm going to bring my family and my best friend. And then the other parent is like, well, my family's already here and they've always hated your friends and family. And then suddenly it's a war zone. So we do want to be very cognizant of, okay, what environment are we actually creating for this child?
Yeah, exactly. No, that's definitely important and a really good caveat. And like you've made the decision that it's not healthy for you to be together, but one day a year can we, play nice and spend that time
and bite your lip.
Yeah.
Like shut up.
Yeah.
Like it's not about you, it's not about the relationship, it's about the child. So and if you can't do that, that's okay. Don't have the joint birthday party.
Yes.
Have 2 birthday parties. And you know what? Trust me. Kids, especially under the age of 10, they would love 2 birthday parties. I mean, I wanted 2 birthday parties. Just saying.
Yes. And, to your point, it's good practice because eventually the child grows up and there's not necessarily that custody arrangement because they're an adult now. But then they are going to have birthdays beyond that and they're going to bring partners home to meet their parents or have a joint event or host Christmas for the family. And do you still want that contentiousness to be there? So I think it's probably good to practice while they're still young and just get used to being around each other in this new context. And that way the future doesn't...
further. I mean, I'm going to expand on that.
Yeah.
And this is, again, we could talk about this all day. There's something to be said that the way parents treat each other is the prime example that children learn from in how they treat other people. So if they see their parents being mean to one another, regardless if you're in the same household or separate household, they will mimic that behavior externally in their relationships, in their interactions at school and beyond. And so if you don't want your child to be a bully or a jerk, then stop being a bully or a jerk to the other parent. And because otherwise children are learning that that's okay and it's not okay.
Right.
So if there's a way that you can be cordial and then feel free to go out with your friends and have a couple of drinks and be like, that asshole and so forth, right?
Yeah.
But you don't have to do it in front of the kid and you don't have to do it within the hearing, of the child, under the same roof.
That's a really good point. So here in the Charlotte area, it's not uncommon to live on the North Carolina side and work in the, South Carolina Fort Mill side or vice versa. So when it comes to custody arrangements, like let's say one parent moves, quote, out of state, they move from South Carolina to North Carolina or vice versa, and they still might be 5 or 10, maybe 15 minutes away from the other parent. What happens in that situation?
I took a deep breath there because that poses a lot more issues than clients ever realize.
It seems so simple. It seems like it'd be very straightforward.
Simple. It seems, it shouldn't be a big deal. Oh, Lordy, it can be a very big deal. And I say this because not that we're necessarily going to, blow everything up. It's the fact that once there is a situation where the children are spending a significant amount of time in the other state. And although I'm not licensed in South Carolina, this does apply both ways, that the courts of said state are a little bit concerned of if they're going to lose jurisdiction. So let me kind of explain how jurisdiction works. So jurisdiction for child custody matters is generally where have the children resided primarily for at least 6 months. So let's say there is a couple that married, divorced, had kids. here in North Carolina, in Mecklenburg County, and they've lived here for years, and they do divorce, and they agree to a custody arrangement, and then one of the parents moves to South Carolina. Well, if the parent who had more than 50% of the time with the children moved to South Carolina, then we have a concern where maybe one day that parent that moved to South Carolina will try to transfer jurisdiction from North Carolina courts to South Carolina courts. Now, that's not to say that anything would necessarily change in terms of parenting time, but then you have these two courts saying, no, I want the kids, and the other court saying, no, I want the kids. And there is what we call the UCCJEA. So there are rules that apply for the most part across all the states in the United States about this very dilemma. But before the move, I would highly advise individuals to consult with their family law attorney first, because we do not want this to turn into a situation where, yes, maybe, again, in that same example, the parent that moved to South Carolina just moved to Fort Mill, which is pretty close. But, oh, wait, now they want to move to Charleston. And now we have a greater distance in between. Mm-hmm. Oh, wait, then the parent in North Carolina actually was spending a lot of their time in New York because of a job. Does that mean now that person has moved out of North Carolina such that no one lives in North Carolina anymore? I don't know, right? Yeah. And so these are all the questions that can come up simply by having one parent cross state lines with the children.
You need a good attorney, it sounds like, to be able to ask these questions.
I've had that case.
Yes. And ask the question before you sign the papers to move to somewhere else.
Yes, please.
We're begging you. All right. So how do financial circumstances affect custody decisions?
Now, a parent who has limited financial means, I'll start there, is not barred from having parenting time simply by their financial circumstance. I want to stress that because I feel sometimes individuals bring up, oh, well, they don't have a job, or, they don't have enough money or housing. A court is still going to give that parent parenting time because poverty or a low socioeconomic status alone is not a means to keep a parent from their child, simply put. Mm-hmm. Now, on the flip side, then there's also the realistic circumstances of not having money, right? So if a parent is homeless, yes, a judge will consider that in terms of the parenting time. If, a parent proves that they're not able to bring the child to and from doctor's appointments, to and from school, or to and from other necessary areas and locations that the child needs to be brought to for their welfare, then a court will take that into consideration. Now, obviously, my family's from New York City, so not having a car is not a big deal for the most part. You just have to walk a lot and, catch the subway. But here in Charlotte, North Carolina, there's definitely plenty of places where you do need a car to get to and from school, to and from the doctor's office. So that's something to consider and will impact the custody considerations for a judge or for parties and their attorneys negotiating a custody arrangement. So it's not so much the financial piece alone, but it's the ability to provide for the needs of the child that matter most.
Right. One thing that came up for me when I was researching for this episode is a parenting coordinator, which I did not know was a thing at all and had never heard of. Can you tell us a little bit about what a parenting coordinator is and what do they do?
Sure. I love the parenting coordinator option. And I say it's an option because here in North Carolina, our courts are inundated with child custody matters. And I will say we have a whole floor in Mecklenburg County, actually more than one floor because one of the courtrooms is not on our floor, just for family-related matters.
Wow.
So you can imagine these courtrooms just running day in and day out, Monday through Friday, 9 to 5 p.m. And so we have what we call a parenting coordinator that can be appointed in high conflict custody matters by a judge. And what essentially a judge is doing via that process is they're finding an individual who has become certified as a parenting coordinator. They are generally family law attorneys that have gone through additional training to get that certification. The judges have a nice little list of them, and the attorneys have that list too. And so we can ask that a judge appoint a parenting coordinator in a case where the parents are having a lot of disagreements and may not be communicating in a way that's productive for providing for the child's needs. And so that parenting coordinator will step in and will have the authority essentially of the court to make certain very focused decisions. So let me caveat that. A parenting coordinator cannot change a custody order. Okay. So if a judge says that, parents have a week on, week off schedule, then the parenting coordinator can't suddenly say, okay, one parent has primary custody. Right. That's not what a parenting coordinator can do. However, if a judge says that parenting coordinator will assist the parties in welfare decisions like school choice, then a parenting coordinator can say, okay, parent one, tell me which school you prefer for the child. Parent two, tell me which school you want for the child, and the parents can bring, the scores of the school, the population, where you got to live to have a child enrolled in that school. And the parenting coordinator is trained to try to help the parents themselves come up with a solution or an answer to, say, the school choice issue. But if they can't, then the parenting coordinator can say, okay, well, the child is going to school B. Mm-hmm. And that be the decision.
Yes.
And that decision be enforceable almost as if it came from a judge. Now, of course, the parents can consult with their attorneys and try to petition that, that decision be overturned. But trust you me, a judge just does not have the resources, the ability and time to do as much resource review and consideration as a parenting coordinator can. Going one step further, parenting coordinators are also trained very often in trying to reduce conflict. Okay. And so they can assist the parents in learning different techniques on how to communicate to better parent between the two of them.
That's great. And who pays for the parenting coordinator? Is that an expense on the parents, or is that provided by the state?
That is definitely on the parents. Okay. Our taxpayers are not paying for that. And I will say, though, parenting coordinators, based on the structure, they turn out to be a lot cheaper than attorneys and having to go to court all the time. Okay. And going one step further, again, they go through a specific type of training that gives them a skill set that they can then impart on the parents, which honestly is worth every penny if you are dealing with a contentious custody situation.
Mm-hmm. Again, tying it back to your children are still seeing all this infighting and they're caught up in the middle of it. So if you could have somebody come in, take both sides, help you understand each other's point of view, but then ultimately make the decision if they need to.
Yep.
Sounds pretty invaluable to the psychological safety of the child.
Yeah. Yeah. And mind you, it's a last resource, if you will. It's not like we automatically appoint parent coordinators to every custody matter. Go one step further, I try as an attorney, if we can, to resolve custody even outside of court. And maybe we'll do like a amicable consent order for child custody, but otherwise judges are not involved in the amicable meeting of the minds, if you will, to a parenting arrangement and welfare decisions for the children.
Got it. And then last question for today is, what is your advice for how to maintain a healthy co-parenting relationship?
Oh, that's a great question. That's a loaded question. I always say, first things first, take a deep breath. Take a deep breath because a lot of parents, understandably, will bring in the history that they've had with the other parent into the current situation. And they will say, well, they never wash the dishes, so how can I trust this person with our child? Or they have never changed a diaper, or they have never done X, Y, Z. And all this stuff that parent validly remembers from the relationship that they shared with the other parent. My caveat in addition to that is no one is born with experience of parenting a child. Everyone has their first time changing a diaper. Everyone has their first time dealing with a 3-year-old's temper tantrum.
Oof, they're rough.
Yes, they are. Everyone has these first experiences. And between you and me, the courts will allow a parent that opportunity to step up, to be able to change the diaper for the first time, to clean the house and wash the dishes and create a safe environment for the child. Now, that isn't to say that if it never happens and the poor child is found in deteriorating circumstances that the court won't step in or other resources won't be available to limit that person's parenting time or provide support for them. But that is to say that, again, no one is born a parent, so we all have to learn. And so when you are co-parenting, patience is the other key. Taking a deep breath, then patience, and then let's work on a communication. I get it. You're going to want to take some jabs because, your ex insulted you a certain way back when. I get it. But it's not about you. Like I said earlier, it's not about you. It's not about the other parent. It's about the kid.
Right.
And so if we can try to take a deep breath, be patient, and work on our communication skills, then I believe a lot more individuals will be able to parent more amicably moving forward. Worst case scenario, and it was kind of coined by one of our local judges here in Mecklenburg County, if you cannot find within yourself the ability to take a deep breath, to be patient, and to work on your communication, then instead of co-parenting, we call it parallel parenting. And what you will do instead is, if you can, once a week, just send an email update to the opposing side, or you can do it via text, but it tends to be a little trickier. And what you do is you limit the updates to the other person to 3 topics and 3 topics only. 1, medical updates, 2, educational updates, and 3, social and extracurricular updates. That's it. Do not take jabs at the other parent's character. Don't share your feelings. This email should be void of feelings. No one cares about your feelings, okay? If you gotten to this point where you can't co-parent, then you're going to parallel parent, and you're only going to share those 3 things. Because at the end of the day, that's the bare minimum of what you need to share with the other parent to make sure that there is some fluidity between both houses and caring for the child. Because no one wants to find out, oh, goodness, the child was supposed to be at a doctor's appointment this morning that I wasn't informed of.
Well, this was incredibly helpful. I'm sure that there are some case studies that we can revisit in the future when it comes to custody. I know that I have one from family experience that I could share in a future episode that is juicy, and it is certainly something.
Better than a Netflix special?
There's no murder that I know of involved, but I think it's still super interesting. But thank you so much for having me to guest host today's episode. It's always fun to be here in the Legal Lounge. And as you can see from this episode, having a experienced attorney in your corner who just wants the best for you and your family, who wants to empower you with the resources and the skills that you need to get through this process of separation, divorce, custody, and then co-parenting and moving on with your life. Modern Legal is the team for that, so make sure you reach out to them.
Sounds good. And thank you, Kristen. Appreciate you.
Thanks for watching.
Thank you for taking the time to listen to our discussion. To learn more about me and the Modern Legal team, go to our website, modernlegalnc.com, or check out the links in our show notes to follow us on Instagram, Facebook, LinkedIn, and YouTube. You can also call us at 704-286-6302. If you have been intrigued by the conversation and would like us to continue our discussions, please subscribe to the podcast and leave us a review. See you next time.